Lawyer in Marietta, Ohio. Today we're talking about pooling and unitization. We've been doing a series of videos on oil and gas leases, and the most recent videos had to do with the savings clauses, the clauses that keep a lease from expiring. Pooling and unitization is both a savings clause, something that keeps a lease from expiring, and a substantive clause that has to do with the conservation of oil or gas in a field. Entire treatises, whole volumes of books have been written on pooling and unitization, so I do not intend to cover all or even most of the aspects of this concept. But in its simplest form, pooling and unitization are two sides to the same coin, which the concept is that the lessee, the oil and gas operating companies, will consolidate leased properties together to form a drilling unit. If you have a lease on a property that's 5 acres, no oil and gas operator can actually drill a well on your land without having to, unless they get other properties together with yours. How much land is necessary is set by state law. Generally speaking, the deeper the well, the more acreage is needed to form a drilling unit. Here in eastern Ohio, with the advent of the horizontal drilling in the Utica Shale, generally speaking, they need 640 acres, and as a practical matter, many of the lessees are wanting 1,280 acres. It's also a savings clause in that it keeps a lease from expiring. So if you have an oil and gas lease that's about to expire, if it has a pooling and unitization clause and the lessee properly invokes the clause, they can keep the lease from expiring even though they've not drilled a well on the property. Here are some issues to look for in oil and gas leases and the concept of pooling and unitization. First, does the lease even have a pooling and unitization clause? Now, there is such a thing as forced pooling, which is governed by state law. That's a topic for another day, so I'm not going to discuss that. Absent forced pooling, the property owner, the lessor, has to have agreed in the lease to allow the lessee to pool and unitize the property. No pooling clause, no pooling. Does the oil and gas lease pooling clause place a limit on the size of the pool? Some of the older leases had 40-acre units or 80-acre units. Some of the more modern leases, to go with the Utica Shale drilling, have 640-acre limits. Some are increasing it to 1,280 acres. Obviously, the bigger the pool, the less the royalty of any particular landowner. So there's an aspect of protecting yourself as the lessor and making sure that they're not putting you in a larger pool than they're allowed to. Next is the concept of good faith pooling, or the flip side is the lessee exercising its ability to pool and unitize in bad faith. Even if the lessee has met the letter of the lease in invoking the pooling clause and including a portion of the leased property into a drilling unit, the question still sometimes arises, is the lessee actually using the clause, using the pooled acreage for the furtherance of its oil and gas production activities? Put differently, do they need that much acreage or that little acreage to fill in a pool? On the other hand, I have seen many times, particularly in the last 4 years, lessees who take maybe 4 or 5 acres of a 100-acre property, include it in a proposed pool, and then claim that the entire lease is held, which oftentimes the black and white language of the pooling clause will allow them to do. But it is evident to everybody that looks that the true purpose is not to include the acreage in a unit for oil and gas development, but really the ultimate purpose is to keep the lease from expiring. These are complicated issues, but it does happen. The next question, assuming that there is no issue of good faith or bad faith, is how was the pooling effected? In order to satisfy a pooling clause, the lessee has to do something. They can't simply throw their hands in the air and say, all right, now you're pooled. Usually the lease will specify how a pool is formed. Some leases say that the lessee must file a declaration of a pooled unit in the county recorder's office. Some leases say that the lessee must file a map of the proposed unit with the Ohio Department of Natural Resources to correspond with a particular well. But the bottom line is the lessee must do something in order to satisfy the pooling clause in order for pooling and unitization to have been technically occurred. And then that brings up the next question, and where its particular importance with respect to the savings clause is, when was the pooling declared? If the pooling was effected after the lease expired, it didn't happen. And I've seen this a number of times in a particular case I just had in federal court. If the landowner's lease has expired, there's no well drilled, nothing else saving the lease, the lessee cannot after the fact declare that the lessor's property or even a portion has been included in a drilling unit. The lease is over. But we are seeing that, and that is one technique that some lessees are trying to do in order to keep leases from expiring. You need to be vigilant of this. Again, pooling and unitization is a very complicated topic. The law is not completely settled on it. If you are having a problem involving pooling and unitization, or you are having a lessee trying to keep your lease from expiring, or claiming that your lease has not expired because of some nebulous claim that your property has been included in a drilling unit under a pooling and unitization clause, you need to find a lawyer. And you need to find a lawyer that has experience in oil and gas. I've dedicated the better part of the last 4 years to helping landowners here in eastern Ohio in the Utica Shale Zone as they confront these issues of whether their leases have expired or not. If you think you're having a problem with your lessee involving pooling and unitization, please give me a call, 740-374-5346, or visit our website, www.fieldsdehmlow.com. Thank you.